We have Supreme Court retired Justice A.K. Patnaik, who gave landmark judgments in Supreme Court while he was in Supreme Court. Sir, very thankful to come to NDTV. Sir, my question is how different Supreme Court now when you were there this time?
When I worked, that is from 2009 to 2014, there was no live streaming of Supreme Court proceedings. So these live streaming of the Supreme Court proceedings is a very good development, which has brought about transparency in the court proceedings. When there was no live streaming, the interactions between the judges and the lawyers sometimes used to get rough. But I think with live streaming, those rough interactions are gone because the lawyer himself is very conscious that he's being watched. The judge is also himself conscious that he's being watched. This is a very good development. Second development is in our times the judge's strength was low. In my time it was 30. And the number of matters listed was so many that Chief Justice could not constitute 5 judge benches, constitutional benches, which are supposed to decide any constitutional issues. During my time, a PIL was also filed, and the lawyer pressed on me, Mr. Vaidyanathan, that constitutional issues must be decided by 5 judge bench. But I thought it is not practically possible. I can't ask the Chief Justice to constitute 5 judge bench for every constitutional issue at that stage. So this is a very good development that constitutional benches are hearing constitutional matters and deciding, because the Supreme Court is basically the highest constitutional court. And third thing, which is not a good development in Supreme Court, is judgments are getting longer and longer and longer. 300 pages, 400 pages, 200 pages. No litigant, no lawyer also these days have that patience to read. Even though the arguments may be long, it is the job of the judge, writing the judgment, to make it as precise as possible. And if you lay down the law in the precise judgments, it will be appreciated and understood better.
Sir, a second thing is if we see now technology is being used in Supreme Court in proceedings, e-filing, affidavit filing, everything. You have mobile. If you have mobile, you can get everything. How useful technology for the delivering justice?
I think it's very useful. Everybody can access the judgment immediately. During our time, it was difficult. Sometimes it used to get delayed when uploading. Now things are very fast. The day judgment delivered, it is uploaded. So the access to all these judgments have become much easier for lawyers as well as the litigants. That's very important.
Also, regional Supreme Court judgments are now translated in regional languages also.
And that's very important because many times demands have been made on the Supreme Court to have other languages. But Supreme Court's official language is English. It's very difficult. Sometimes demand is made to have more benches in the south and the east. So by this technology, everybody is accessing, everybody is able to watch the proceedings. So I think this demand is going down gradually.
Sir, second thing, you watch a younger generation now. So what's your advice to the younger generation who are in law field basically?
You see, the younger generations, they're using technology all right. And they look at the judgments very fast because the research, through technology you can research very fast. But my advice is they should read also the books, the research books, the AIR's the finding process must be long so that your mind keeps on working. What could be the answer? In our times we used to sit over one point whole day. And ultimately you find that your mind has become so good, it can comprehend any kind of proportion, think of it.
Sir, last question. Your famous Lily Thomas judgment, still it is in public Rahul Gandhi case came, was disqualification matter. You have given landmark judgment this on the disqualification of public MP and MLA. That was welcomed by the people, common people, but not by the politician. What you say on this, sir?
See, in my opinion, Parliament is sovereign. It has got very vast powers, and the Constitution is subject to Constitution. Similarly, Legislative Assembly in the state, they have got vast powers to legislate and to debate many matters. Therefore, those who go as representatives to the Legislative Assembly or Parliament must have a clean reputation. People will trust in them. And if somebody has been convicted and under the Representation of People Act, he gets disqualified also, that's the provision in the Representation of People Act, Section 8. He should not remain in Parliament, or should not, right, unless his conviction stayed. So, and it provides that conviction and sentence beyond 2 years or more, right, 2 years or more, they get disqualified. But there was a provision there which had been made sometimes that if you file an appeal against the conviction, then you need not get disqualified, you will continue in the house. I thought this is not correct. Either you get your conviction stayed by the higher court, or you get out, right? After your conviction is set aside, again come back elected. So I think to keep the house clean, both the houses, assembly and the parliament, or anywhere, and people's representative must go out till so long when they are convicted for more than 2 years. This is my thinking, and in my opinion, judiciary must avail this kind of opportunity wherever it's possible to exercise power within the judicial domain without crossing the limits of the Constitution and clean up. I thought I could do it with my power. I just struck down that provision. We had the power to strike down that provision. If it is a violation of the Constitution, struck down Section 8(4)(a) of the Representative People Act.
Thank you very much, Justice A.K. Patnaik, speaking to NDTV. In Delhi with camera person Pawan Kumar, Ashish Bhargav for NDTV.